you need so much money because from experience and from past cases, that is what the court is likely to do. And so at the initial stage, our primary preoccupation is getting the client out of custody as soon as he takes plea. And when he takes plea, bail is imposed, let's say 10 or 15 million shillings, which is a substantial amount of money in any currency. Members of the fourth estate will run huge headlines. In 3 hours, accused so-and-so has raised the bail money. That will be the selling headline. But members of the press sometimes do forget that some of these accused persons actually don't have that money. That money is raised by friends, and some of you have actually contributed to raise that bail money. People who actually live by their sweat do not have 15 million to produce at a flash. You would know every well-to-do person would not be having loose change of 15 million shillings. It would be invested somewhere. It could be in treasury bills. It could be in a fixed deposit. So the story that is never told is the agony that accused persons go in raising this money. Many of the times it is Arambe money. Associates, business associates, friends, relatives put this money together and it is posted. So when your headlines say 15 million in 3 hours, it gives a different perception. And indeed, many of the times, members of the public gain the impression this man must be guilty of corruption. Where did he get 15 million in 3 hours? And so, from the defense perspective, I suggest to you that you may need to be finding out where this money is coming from. But that is the first angle. The second one, immediately a person is accused, he takes plea, there will be huge story on media, electronic, print, and everywhere. Many of the times, these stories have devastated families. Particularly, high-ranking government officials, wealthy people with high status in society, immediately he is charged. Some of them fall into depression. Some of them have school-going children. And these school-going children, they are bullied by their peers. Their peers would say something like this, Maringo bure, pesa ni ya wizi. And this is a primary school child or a secondary school child. It brings depression in that family. And now the role of you as a lawyer changes from giving legal advice, you literally become a counselor. And at times, we are called upon actually to tell our clients, could you kindly look for a professional counselor who will not only give you some counseling, but also your family. So the fact of being charged alone is a serious matter. And it is for that reason that the DPP does not take the decision to charge anybody lightly. Because whether you are ultimately acquitted or not, immediately you take a plea, you are in trouble. Some of your so-called friends will not even ring you. They will not want to be in contact with you. You get isolated. Your family is being ridiculed. Your children are being ridiculed in school. And your defense lawyer turns counselor. Let me now deal with the other aspect of our role when disclosure is done by the DPP. As you all know, The Constitution requires all the documentary exhibits and all the evidence be disclosed to the defense. As soon as we get these disclosures and we have read through, we are called upon to advise the client. You may be able to tell your client, from the evidence presented by the DPP, if it all comes through during the trial, chances are you will be convicted. And the client has to make a decision. The decision being, do you want to change your plea? Do you want to plea bargain with the prosecuting authorities? Do you want us to approach the DPP with a request for diversion instead of you being prosecuted, for the DPP to consider an alternative? These are the things that go through once we have a disclosure. Of course, an accused person would want to know, okay, fine, if I plea bargain, what does that mean? So you tell him, you'll be convicted. And if you're convicted, you cannot get certain jobs. You cannot get visas to some countries. And your conviction may affect your life or your workplace in a drastic way. And that is what makes a client to make an informed decision. He may then say, very well, I am not going to plead guilty. I'm not going to enter into any plea bargain. Let the case take its course. But at that stage, the lawyer is still playing his advisory role. And this advisory role is done throughout, from the time he is a suspect to the time he is either acquitted or convicted. And then now let's say in a situation where the decision made by the client is that let us go on with the trial. That takes us to the next role of a defense lawyer, is legal representation at the actual trial. Many of the times, the role of a lawyer at that stage is to look at the charge sheet, look at the law creating the offense, the reason there being to identify the components of that offense, or what lawyers call essential ingredients of the offense that your client is charged with. Once you have identified all those essential ingredients or elements of the offense, the next thing is, does the evidence disclosed by the DPP cover all these components, or is there a gap? Once you identify the gap, you put it down. It could be in the charge sheet, it could be in the supply of the evidence, and that is put down to be revisited as the case goes on. As you know, journalists who cover court proceedings for a long time, they are sometimes better even than the defense lawyers. They can tell you with a degree of certainty, because they have studied human beings, they can tell you with a degree of certainty whether this man will be convicted or whether he will be acquitted. And this is from the way the charge sheet is framed, the evidence that is coming through. But the biggest role that a defense lawyer plays, he tries as much as possible to lock out all the evidence of the DPP. Lock it out legally. Because if you cannot lock it out, your client will be convicted. That is the reason why the decision to prosecute him was taken in the first place. And so our main job is to try and lock out the DPP's evidence within the law. And this is what we call admissibility of evidence, the criteria that the law uses to accept evidence. In the discussion that we had earlier of Wanjiru's case, there was a talk of confession. I'm sure all of you have heard about that. And I'm just using that as an illustration. You can have a fantastic confession, a confession that once accepted by the court, you do not need any other evidence. That accused person is as good as convicted. But a defense lawyer will ask, how did you obtain that confession? Was it obtained in accordance with the law? Was it recorded in the manner provided by the law? Was it recorded by a person of the rank that is supposed to record it? Was the accused person represented? Was he given that information that is entitled to representation? Was he asked whether he wants an advocate present or a friend present? And was all this documented at the time it occurred? If this did not happen, that excellent confession you have will be thrown out. And once it is thrown out, if you didn't have any other evidence, that is the end of the case. One time in my days as a prosecutor, I had a beautiful confession. I was looking forward to a conviction. When the judge threw out the confession, I knew I'm done. And the accused person was actually acquitted. And how does a prosecutor feel going home with that acquittal? He feels extremely bad. The prosecutor is convinced this person did not only commit the offense, he confessed to it. But the law, through its legal strictures, has allowed a confessed killer to walk free. That's how prosecutors feel when these things do happen. And so our role when you see us in court is to try as much as we can to look out the DPP's evidence. Let's say the DPP has video recordings. The lawyers will go to town about, is it the original? Has it been tampered with? What is its integrity? Who took it? Where is the certificate for electronic evidence? And the lawyers will go on and possibly successfully lock out that evidence. The other short example I will give is how you obtain that evidence. Of course, the office of the DPP does not itself go out to obtain evidence. This evidence is brought to the office by the investigative agencies. At times, the investigating agencies do obtain evidence through violating rights to privacy. They come to your house, no warrant to search your house, take away probably incriminating evidence, and that evidence may be enough to send you to jail. What does your defense lawyer do? He will pitch tent on Article 31 of the Constitution, the right to privacy, and try to make his case that this is illegally obtained evidence and it cannot support this case. So during the trial, the lawyer will try each and everything permissible under the Evidence Act to lock out the evidence of the DPP. And if he succeeds in doing so, very well, the case will be thrown out. You may not succeed in locking out the evidence, and your next course of action could be to create substantial doubts. Because remember, the DPP has to meet a very high threshold. He must prove his case beyond reasonable doubt. And so let's assume there is some house breaking into this hotel, and among the suspect paraded up is Dr. Nyakundi, I met Dr. Nyakundi many years ago when he was a young journalist, and he knows a lot about what goes on in courts. And the key evidence in that case is fingerprints. Fingerprint evidence is another impossible kind of evidence to go around. The fingerprints of Dr. Nyakundi have been found in room 322 at the Serena, and he is charged among other people. If Dr. Nyakundi does not give a reasonable explanation for his fingerprints being found in that room, he is as good as convicted. So what does the defense lawyer do? He will have a chat with Dr. Nyakundi. Were you in this hotel? Yes, I was in that hotel. Did you go to this room? If he insists, I never went to that room, and the scientific evidence of the fingerprints he was in that room, he will be convicted. But if Dr. Nyakundi says, I was in that room, a fellow journalist so-and-so was in that room, and I went to say hello to him, we had a chat, that explains and throws a doubt as to whether, because legitimately, he has explained why his fingerprint is found there. The other cases, again, dealing with scientific evidence, it's like DNA material. You are accused of raping Miss X. Your case is, I do not know Miss X. I have never had any contact with Miss X. Certainly, you will be convicted. Your DNA material has been found there. You do not share DNA material with anyone else, and you will certainly be convicted. But if you put in the narrative that this is your girlfriend, he happens to have 3 boyfriends, and you are caught by one of them, the court may then say, well, there is a doubt. It's doubtful. This material legitimately was found there, and there was a reason to raise a false alarm. Chances are you could very well go home because you have raised a reasonable doubt. And so these are the things that defense lawyers do at the trial to either try to lock out evidence because you can lock it out under the law, or to put a case that raises reasonable doubt as to the guilty of the accused person. The next thing I'll talk about is defense lawyer as an officer of the court. The defense lawyers are all admitted advocates. They are expected to be officers of the court. And so, as officers of the court, they cannot be party to misrepresentation or doing things to mislead the court. They have a duty of candor. They have a duty of honesty to the court. And if they live true to their oath of office, it will not be for a defense lawyer to tell his client to give a false narrative. Whether or not Dr. Nyakundi went to that room, that must be Dr. Nyakundi's truthful account. It is not permissible for the lawyer to plant this story on Dr. Nyakundi. That will be unethical. That will be acting contrarily to your role as an officer of the court. Whether or not Nyakundi was in that room, that must be a truthful account, which account must come from him. It cannot be an invented story to defeat the cause of justice. And that is the role of a defense lawyer as an officer of the court, so that he will not participate in creating false alibis, false evidence to defeat the cause of justice. If he does so, that is not only a criminal offense, subverting the cause of justice, among other offenses, it is a disciplinary offense for him as a lawyer and could be removed from the role of advocates. Then finally, I will talk about the lawyer as a member of society, as a member of the community at large. And he must therefore be a person who seeks for justice. A lawyer, whether defense, whether prosecuting counsel, must be a seeker of justice. When a crime is committed, it is a crime against society. It is a crime against the republic. All of you witnessed, or you heard the stories about convicted terrorists escaping from a prison. Now, that would concern every law-abiding citizen. You will not find a team of defense lawyers celebrating that a convicted terrorist has escaped from prison. When he escapes from prison, he is a threat to the society as a whole. And so the defense lawyer has his role of seeking to ensure justice is done. And in seeking to ensure justice is done, is for him to play his role as a defense lawyer within the confines of the law. So that if the client you are representing truly convicted an offense, you have defended them to the best of your ability and within the law, and is ultimately convicted, that is justice. And if you are a professional man, chances are you would have told him long time ago that there is the highest probability that you will be convicted. There is a story told of a client who called his lawyer. Judgment was being delivered. And he called his lawyer and he was asked by his lawyer, what did the appeal court rule? The client responded, justice was done. The lawyer knew the conviction was upheld. And the client did not want to say, we lost the case. He simply said, justice was done. In concluding, members of the Fourth Estate, you have over the years, deliberately or otherwise, given the defense lawyers bigger and prominent place in both electronic and print media. Very little is heard about the prosecutors. And many prosecutors who have served 10, 15, 20 years, they start asking themselves, are we engaged in a thankless job? Please, my plea to you, make these prosecutors feel that we appreciate the job they do for the good of all of us. Thank you very much for listening to me.
Tunaahidi mashtaka yenye haki na usawa.